Okay, so welcome everyone to today's webinar on small amount credit contract and consumer lease reform. My name's Carly Hanson. I'm from Community Legal Centres Queensland, and here today we have Gemma Mitchell and Roberta Graylish from the Consumer Credit Legal Service in WA. So welcome Gemma and Roberta. Firstly, I would like to acknowledge the traditional owners of the land on which we're holding this webinar. So today in Brisbane, where I'm presenting from, the people are the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people throughout Queensland and throughout Australia, as well as being presented from our colleagues over in Perth, I'd like to pay my respects to the traditional owners of the land throughout the country and welcome any First Australians listening in today. So, as I mentioned, we're here to talk about the national legislative changes to payday lending and predatory leases. So consumer leases and payday loans are often targeted to the most vulnerable people in society, and community legal centres and consumer groups frequently assist victims of this kind of predatory behaviour that ignores or hinders the person's ability to repay the debt. Today, Gemma and Roberta will provide you with an update on recent changes to the national laws, or the pending changes around payday lending and predatory leases. So the webinar is being recorded and there are PowerPoints available. So I emailed those out to everyone who registered this morning. There are two versions of the PowerPoint. One is for public consumption and that has been added to our website. And the other, which I believe contains some additional slides that was emailed to you. Both copies have been put onto the handout section of the GoToWebinar control panel if you missed out on the email and would like to download those now. So we will get started very soon. I just wanted to let you know that you can ask questions, of course, for Gemma and Roberta to answer. We'll hold those over to the end of the webinar and I'll remind you how you can ask those questions. If you experience any technical issues or sound dropping out or anything like that as we go through, please do either email me, so you can respond to the registration email, the email that I sent this morning, or pop a note to me in the chat box or the question box of the GoToWebinar control panel. So I think hopefully that's everything from me and I'll come back in at the end. But now we'll get started and I'll hand over to Gemma and Roberta in WA. Thanks, guys.
Thank you, Carly. So good morning to those of us in WA and afternoon to those elsewhere. And thank you all for tuning in to learn more about the small amount credit contract and consumer lease reforms. My name is Gemma Mitchell and I'm the Managing Solicitor at the Consumer Credit Legal Service WA. I've been a solicitor at CCLS WA for over 4.5 years, becoming Principal Solicitor about 1.5 years ago and then Managing Solicitor about 1 year ago.
And my name is Roberta Graylish. I'm a Senior Solicitor at the Consumer Credit Legal Service WA and I've been with CCLS WA for about 2 years now.
So today we're going to talk to you about small amount credit contracts, otherwise known as SACs or payday loans. We'll also be talking to you about consumer leases. Originally, we'd planned to run this webinar as part of our general webinar on credit and debt issues that we presented back in November 2017. However, the topic of payday loans and consumer leases was so big that we decided that it needed its own webinar. And what we were hoping back in November was that by the time we did the webinar today, the proposed changes to payday lending and consumer lease laws would have been enacted and we would be here talking to you today about those new laws. However, that has not yet happened. So what we're going to talk to you about today are the proposed changes to the law and what you can do to lobby for change, thanks to some resources that have been provided to us by our colleague Denise Boyd at the Consumer Action Law Centre in Melbourne. Now, the usual disclaimer, our presentation is for information only and does not constitute legal advice. Before we go too much further into the presentation, we're going to tell you a bit about our organisation, the Consumer Credit Legal Service WA, and what services our centre provides.
The Consumer Credit Legal Service WA, or CCLS WA for short, is a not-for-profit charitable organisation that provides legal advice and representation to consumers in Western Australia in the areas of credit, banking and finance, and consumer law. CCLS WA operates a free telephone advice line. This daily service allows us to provide legal advice and information to all members of the public, including those in rural and remote regions. CCLS WA's telephone advice line number is 9221 7066. However, advocates can call through our admin line 6336 7020 and speak directly with the solicitor. Where a matter is too complex to provide a one-off telephone advice, we look to open a case file if we have the resources to do so. CCLS WA also plays an active role in community legal education. CCLS WA goes to high schools, delivers seminars, runs information stalls, talks with community advocacy groups, and has 2 monthly radio segments on 2 different community radio stations. At CCLS WA, we feel that it is important that everyone can have a good understanding of how credit works and are aware of what steps they should take if they ever get into financial trouble. We provide resources such as fact sheets and sampled letters on our website at www.cclswa.org.au. We also undertake law reform work. Our office consists of 3 solicitors, a managing solicitor, an office manager, legal administrative assistant, bookkeeper, and approximately 20 law student or law graduate volunteers. And it is our volunteers who run the telephone advice line. The work that we do and the way our centre operates is all reflected in the guiding principles of our service, that consumers who know their rights are less likely to need advice in the future. Consumers who are financially literate will make positive financial decisions. Staff and volunteers who are experts can impart their knowledge onto other advocates, and collaborating with other service agencies will provide innovative service delivery to a specific target group.
Okay, so Roberta mentioned our law student volunteers. Before we get going, I wanted to thank our volunteers, Naomi Zuvela, who's a law student at the University of Notre Dame, and also Sarah Anucic, who's a solicitor on secondment with us from the Australian Government Solicitors. Both of them assisted Roberta and me in putting together our presentation. So I'm now going to give you a brief overview of what we're going to talk to you about today. Our presentation can be broken down into 5 key topics: payday loans, consumer leases, proposed changes to the law affecting both areas, the push for change, and then we'll do a quiz at the end, and you'll need a smart device to play along. So firstly, I'm going to go through a brief introduction to payday loans, followed by a discussion on the current laws around payday loans, the general responsible lending laws that apply to all consumer credit loans, and a case study. Roberta will then present to you on consumer leases, and we'll go through a brief introduction to consumer leases, the current law, issues with consumer leases, and a case study. We will both then run you through the proposed changes to the law in response to the independent review of SACS and consumer leases and the government's response to each of the recommendations that came out of the independent review. I will then take you through the push for change and the role consumer advocates have in lobbying for this change. And finally, we'll do a quiz to test your knowledge in how well you've been paying attention, and hopefully we'll still have time at the end to answer any questions. So what is a payday loan? Well, as it says on the slide, payday loans are also known as small amount credit contracts or SACS. They're loans of up to $2,000 for periods of between 16 days and 12 months. Back in 2016, we engaged an intern through the McCusker Centre for Citizenship to produce videos for our website. The link to the one he produced on payday loans is on the slide there. We won't play this video now as it may not play correctly due to the webinar format, but it's available on our YouTube channel, our website, and you can click on the link and watch it in your own time. Payday loans are advertised as a fast and easy solution, but can often land consumers in hot water. The image at the bottom of the slide has been taken directly from a payday lender's website. It features 2 sliding scales that calculate the total amount of a loan depending on the amount of the loan and the time frame for the repayment. So as you can see, while the consumer is considering a loan of $1,200 to be repaid over 5 months, they will end up paying an extra $480 in what is classed as expenses, which basically just means the fees that are charged by the payday lender. So this brings the total amount of the loan to $1,680. That illustrates just how easy it is for some of our clients to get themselves into difficult financial situations. On this slide, you can see our infographic on payday loans, which is available on our website. The infographic sets out an overview of the current law relating to payday loans. Fees are capped, however, we consider that they're still very high. Lenders are able to charge a 20% establishment fee, 4% monthly fee on the loan, and have the ability to charge default fees. The default fee is not capped, so lenders can charge what they like, as long as the total amount that a borrower ends up repaying on the loan isn't more than double the amount of the principal amount borrowed. You can also see on our infographic here that we've set out alternatives to payday loans, such as negotiating with the credit provider, getting a Centrelink advance, or a no-interest loan. On this slide, you can see our fact sheet on payday loans, which is also available on our website. This fact sheet highlights just what the laws around fees mean for consumers. At the bottom of the slide, we have some practical applications of these laws. You can see that if a consumer takes out a loan of $250 over 12 months, they could end up repaying $420. Now, if someone is needing to resort to a payday loan in order to have access to $250, it's likely that they're in a poor financial situation, and the amount of $420 would be a significant amount of money. Payday lenders often advertise that they don't do credit checks, and you can often get the cash directly deposited into your account in minutes. However, this doesn't mean that they won't list a default on the borrower's credit file if the borrower defaults. At the bottom of the slide, you can see a link here to our website where more resources are available. Payday lenders argue that payday loans are a convenient product for customers who may be excluded from more mainstream financial services, and that the higher fees and other charges reflect the greater risks the sector bears when lending to individuals with poor credit histories. However, we would argue that these loans target the vulnerable, charging them exceptionally high fees that encourage loans to be renewed and thereby lead to higher levels of poverty. A recent news article by the ABC reports that the unemployment rate in Western Australia hit a 16-year high in March this year of 6.9%. This is the highest rate in the country. So people in WA really are doing it tough. This can make them very easy targets for payday lenders. These loans may seem like an attractive option, but can quickly escalate into a cycle of repetitive borrowing. This exact issue was highlighted in a recent article by CCLSWA committee member and executive officer of the Financial Counselling Association of WA, Bev Jewell. Bev has also seen the effect of what she describes as payday lender vultures preying on vulnerable Western Australians. In her article, Bev outlines just how easy it is to get sucked into the pitfalls of payday lending. Perhaps someone is suddenly made redundant and then they suffer a financial crisis, such as their car or fridge breaking down. Some people may ask for a loan from a trusted friend or family member. But what about those who do not have that luxury or are too embarrassed to ask? Those suffering financial hardship may be unable or unwilling to see the true costs of these products, such as exorbitant application fees and high monthly fees. So to summarize, there are a number of problems with payday lending, including high establishment fees, monthly fees, default fees, smaller loans that lead to larger loans, the cycle of repetitive borrowing, multiple debts with multiple lenders, reliance on payday loans that leads to a debt spiral. These loans don't assist financially vulnerable consumers to get out of debt, but add to it. Bev's article also highlights the unsatisfactory responsible lending provisions for consumer leases and payday loans in Australia, which I will go into further detail over the next few slides. Payday lenders must abide by the responsible lending obligations that apply to all consumer loans. This means that lenders and brokers must make reasonable inquiries about the borrower's financial situation, requirements, and objectives. They must also verify the financial information that has been provided to them by the borrowers. This may be done by asking for copies of documents such as payslips, Centrelink statements, or bank statements. The broker or lender must then make a preliminary or final assessment about whether the credit contract is not unsuitable for the consumer based on this information. A loan is not unsuitable for a borrower where they are able to repay it without substantial hardship. Now, apologies for the double negative there, but that's just how the legislation is worded. If the loan is granted, a borrower can request a written copy of the assessment, which the broker or lender must provide to them. In simple language, responsible lending means that the lender has to calculate a borrower's income and expenses and calculate whether they can afford the loan. Additionally, there are specific requirements for payday lenders. Payday lenders must also obtain the borrower's bank records for the past 90 days. The loan is presumed to be unsuitable where the borrower is in default on another payday loan, has had 2 or more payday loans in the past 90 days, or where the borrower receives at least half of their income from Centrelink and the repayments of all the payday loans they have, including the loan applied for, would exceed 20% of their income. This presumption operates so that the borrower will be deemed to only be able to comply with their repayment obligations with substantial hardship unless the contrary can be proved. We're currently acting for a client with multiple coexisting payday loans. However, our assessment of these loans shows that the client had a sufficiently high income to service these loans, and so we expect the presumption of unsuitability in this instance may be easily rebutted. Despite his income, his circumstances are such that he is a vulnerable consumer. This is one of the reasons why consumer advocates would like to see some bright lines drawn rather than just a presumption. But we will discuss these recommended reforms later in our presentation. The Cash Converters case. So as most of you would know, Cash Converters is a common provider of payday loans. Back in 2016, ASIC investigated Cash Converters. They were found to have breached their responsible lending obligations between 2013 and 2016 by failing to check if customers who took out loans online could afford to pay them back. Rather than calculating the actual expenses of their potential customers, Cash Converters used a benchmark figure and did not take each client's individual circumstances into account. Cash Converters had to repay fees of $10.8 million that it had received under 118,000 small amount credit contracts. Cash Converters was also fined $1.35 million as a penalty for breaching the laws. In total, it had to pay $12 million for the breach. This is an example of a payday lender flagrantly breaching the responsible lending provisions. Most borrowers that come to us for assistance are often in financial hardship. They aren't aware of the responsible lending laws around the loans they took out. They can often be hesitant to lodge disputes against the lenders, even if the laws have been clearly breached, as they are concerned that doing so may mean they are prevented from taking these loans out again. Even when consumers are made aware that the lenders have breached the laws, the consumers are so vulnerable that they are still prepared to take out more loans with them. This is why it's crucial that tougher laws are put in place to protect these consumers. Now I'm going to tell you the story of one of our clients, Christina. Christina is a 74-year-old Indigenous Australian whose income is derived from a Centrelink pension and a superannuation pension. Christina has extensive expenses, due primarily to her role as legal or de facto guardian to 8 grandchildren. Christina experiences crippling financial difficulty. She lives in government housing and struggles to manage her living expenses while taking care of her 3 children and 8 grandchildren. All of these facts were known to Christina's lender, Money Magic. So between March 2012 and October 2014, Money Magic approved 19 payday loans and advanced a total of almost $9,800 to Christina. At the time she approached CCLSWA for assistance, Christina had made repayments totaling nearly $12,300 on these payday loans. In our view, all 19 payday loans were unsuitable for Christina under the responsible lending provisions. Christina could not afford the repayments without suffering substantial hardship. For 2 of the payday loans, Money Magic failed to obtain any form of supporting documents before it approved and advanced the loans to Christina. For the remaining 17 payday loans, Money Magic appeared to discharge its obligation to make reasonable inquiries into Christina's financial position and to verify her financial position. They had requested Centrelink and bank statements, which had been provided to them. However, it was clear to us on our review of Christina's supporting documents that there was no way she could have afforded to repay the loans. In our view, Money Magic's request for and purported review of the documents did not amount to a verification of Christina's financial position at the time of each payday loan. Had they properly considered her position, they would not have granted the loans. In addition to the 19 payday loans, between January 2011 and July 2013, Money Magic also provided Christina with 5 personal loans. In CCLSWA's view, in 4 of these 5 loans, Money Magic breached their responsible lending obligations. So, in terms of remedies, our first option was to go to Money Magic's IDR, arguing the loans were unsuitable and that Money Magic had breached its responsible lending obligations to Christina. Money Magic denied the allegations, and so the next step was for us to lodge a dispute with Money Magic's EDR scheme. Now, due to the confidential nature of EDR proceedings, I don't want to go into details and say exactly what the outcome was, but I can say the client's complaint was partially successful and received a fairly positive outcome. So on this slide here, I've set out a table which lists the date, the amount, the date of the repayment, and the amount repaid for each of Christina's loans. Now, you can see that with the exception of the first and the fourth loan, each time Christina took out a loan, it was either greater than or equal to the previous loan. And you can also see where the debt spiral started. That is, where Christina started taking out a loan to repay a previous loan. This happens on about the 5th loan for $350 that she takes out on the 8th of November 2012. So she repays that loan on the 4th of December 2012, but the subsequent loan is taken out on the 3rd of December 2012, the day before the previous loan is repaid, indicating that this loan is repaid by this loan, and so on. Now, each of these loans was taken out in store. So what Christina advised us was that when she went to get another payday loan, the money she received in her hand was much less than what she'd requested to borrow. It hadn't actually been explained to her that part of what she was borrowing was going to pay back her existing loan. She had a direct debit set up and was repaying her loans by direct debit, but wasn't keeping track of the repayments. So even though she was getting this lesser amount in her hands than she'd asked for, she was so desperate for the money, she didn't question this at all with Money Magic because she was concerned that if she did question it, they wouldn't give her the loan at all. Now you can see as well that the amount borrowed by Christina steadily increased from around $350 at the time to $960 over a 2-year period. Christina only came to us for advice when she was unable to meet the repayments on the $960 loan, and Money Magic refused to loan her any more money. So I'm now going to hand you over to Roberta, who will talk to you about consumer leases.
Okay, thank you, Gemma. Consumer leases are agreements for access to domestic goods, for example, a fridge or washing machine, where consumers are locked into an agreement to pay off the good over several years, often with an offer to buy the good at the end of this term. Consumer leases tend to attract a similar demographic to payday loans, low-income earners from low socioeconomic backgrounds who are usually the recipients of Centrelink benefits. Consumer leases target vulnerable Australians and are often marketed as a fair go or affordable alternative. This perception is very problematic as they are often one of the most expensive ways of accessing credit. There is no shortage of issues with consumer leases. And at CCLSWA, we have time and time again seen the effects these problems have on vulnerable consumers. Again, here we intended to show you a video, this time a Channel 7 news report, which came as a result of the lobbying we did in Canberra in support of fair finance options for consumers. However, instead we have provided you with the link here on this slide, and we would encourage you to view it later, as it highlights some of the problems that we will go through today, such as no caps on consumer leases, which means that consumer lease providers can charge whatever they like, regardless of the retail price of the goods. Consumers usually pay at least 3 times the retail price of the goods. The poor disclosure cost is another issue highlighted in the news report. Consumer lease providers only advertise a low weekly amount rather than the full cost of the lease. They don't advertise the recommended retail price of the goods or the annual percentage rate. There is also a high amount of irresponsible lending occurring when it comes to consumer leases. At CCLSWA, we continue to see consumer lease providers signing low-income Australians up to these agreements, even when they can't afford to make repayments. Finally, consumer lease agreements frequently and repeatedly exploit Centrepay. Centrepay is a bill payment service for people receiving Centrelink payments. Many consumer lease providers take their fees automatically out of people's Centrelink payments before it even reaches their bank accounts. There are more Centrepay deductions, in terms of number, not value, for consumer leases than education, housing, water or gas. Consumer leases are regulated under Part 11 of the National Credit Code, which I will abbreviate to NCC going forward. A consumer lease is defined at Section 169 of the NCC as a contract for the hire of goods by a person for a specified time at a specified rental under which they have no right or obligation to purchase the goods. If the lease contains an option or a right to purchase the goods, it may be a sale by instalments agreement under Section 9 of the NCC, and thus potentially a regulated credit contract. And as such, lenders, or lessors in this instance, are required to comply with the provisions that are largely equivalent to the responsible lending provisions imposed upon credit providers. These are similar to the provisions that govern lenders for payday loans, which Gemma explained earlier in this presentation. So now I would like to reintroduce the story of our client Christina. As Gemma has already brought us through how Christina was time and time again approved for unsuitable payday loans and was a particularly vulnerable consumer, it should come as no surprise to you that she was also approved for 2 unsuitable consumer leases. In 2013, Christina entered into a consumer lease with Easy Renters or Us for the rental of a computer. In 2014, Christina entered into a second consumer lease with Easy Renters or Us for the rental of a television. At the time of each of these leases, in addition to general living expenses, Christina had a number of other debts, including the payday loans and personal loans with Money Magic. Christina was told by representatives from Easy Renters or Us that at the end of the lease period she could make an extra month's payment and she would own the goods. At the time that Christina came to CCLSWA, she had paid $2,060 for the computer and still owed $800. For the television, Christina had paid $900 and still owed $1,400. CCLSWA advised Christina that even if she paid the extra month, she would still not own the goods unless her offer to purchase the goods was accepted by Easy Renters or Us. CCLSWA also advised Christina that Easy Renters or Us would likely require her to pay a higher amount than just 1 month's repayment. CCLSWA was able to negotiate another positive outcome for Christina, and she was able to keep the TV and computer at no further cost. So now that we've introduced you to payday loans and consumer leases, the current law applicable to these 2 financial products and the problems with them, we will move on to discussing the steps that have been taken towards changing the law. An independent review of payday loans or small amount credit contracts was conducted by an independent body in 2015-2016. Their final report was provided to the government on the 3rd of March 2016. The final report made 24 recommendations relating to payday loans and consumer leasing laws. On 28 November 2016, the government released its response to the review and recommendations. And in the following slides, we will explain each of the recommendations as well as the government's response to each of the recommendations.
Thanks, Roberta. Okay, so recommendations 1 to 10 relate to payday lending. The first recommendation related to affordability. Now, currently the laws around the cap on the repayments, known as the protected earnings cap, apply only to Centrelink recipients. Now, if you remember from what I said earlier, the cap on repayments means that anyone who receives at least 50% of their income from Centrelink has their repayments capped at no more than 20% of their gross income. I'd like to remind you of our client, Christina. Now, according to our calculations, Money Magic had complied with this requirement. Christina's repayments were no more than 20% of her gross income. The problem was that her expenses were almost as high as her income. So the first recommendation to come out of the review is to reduce the protected earnings cap from 20% of gross income to 10% of net income, and not just for Centrelink recipients, but for all borrowers. The government accepted this recommendation and were very much in favour of it. This will now provide a bright line test and will force lenders to have to comply with their responsible lending obligations in order to calculate the borrower's net income. There's been a huge backlash by industry on this recommendation, and it appears that this provision of the draft bill may be the battleground for consumer advocates to fight. Many opponents do not believe that the cap should apply to non-Centrelink recipients. Our argument is that our clients that we see who are non-Centrelink recipients only resort to payday loans when they've exhausted all other forms of credit and are just increasing their debts by adding to them with the payday loans, and it's not assisting them in any way. So the cap should apply to them. The second recommendation was to remove the rebuttable presumption that a loan is presumed to be unsuitable if the consumer is in default under another payday loan, or if the consumer has had 3 or more payday loans in the 90-day period before the assessment. The government accepted this recommendation, which we're pleased about because, as I explained earlier, this presumption was often too easily rebutted in cases of clients who have high incomes. The third recommendation was to maintain the existing ban on credit contracts with terms less than 15 days, known as short-term credit contracts, which the government accepted in full. The fourth recommendation was that direct debit fees should be incorporated into the existing payday loan fee cap. The government noted that this recommendation was the responsibility of ASIC, and I'm pleased to advise that the recommendation was put into force by ASIC. The fifth recommendation was that in order to be classed as a payday loan, the credit contract must have equal repayments over the life of the loan, although exceptions were noted that this may be necessary in some circumstances. But where a contract didn't meet that requirement, the credit provider should be unable to charge more than the 48% per annum interest rate, which is the maximum amount permitted under the National Consumer Credit Protection Act. The government partially accepted this recommendation. It supported the recommendation payday loans should have equal repayments, but it didn't accept that the limit on the 48% interest rate cap because it didn't want to create a specific penalty regime for this requirement. The sixth recommendation was that a national database of payday loans shouldn't be introduced for the time being, although major banks should be encouraged to participate in comprehensive credit reporting as early as possible. The government accepted that recommendation, noting that it didn't preclude the industry from developing its own database. We think this was a lost opportunity because a regulated database of payday loans would both improve the ability of payday loan providers to comply with the law and provide oversight and governance to the industry lenders. The seventh recommendation was that the 4% monthly fee cannot be charged after the payday loan has been discharged by an early repayment. The government accepted this recommendation in full, which we think is positive for consumers because it seems a bit unfair to charge a monthly fee when the consumers repaid the loan early. The eighth recommendation is that payday loan providers should be prevented from making unsolicited payday loan offers to current or previous consumers. The government accepted this recommendation in full, noting that consumers should only apply for a payday loan when they proactively choose to do so, rather than being prompted. We're aware of vulnerable consumers that we've assisted to escape their debt spirals who continue to be contacted by payday lenders. And we see this as particularly predatory lending to very vulnerable consumers, especially our clients with drug or gambling addictions. For them, these offers can be particularly hard to resist. The ninth recommendation is that payday loan providers should not receive a payment or any other benefit for a referral made to another payday loan provider. The government rejected this recommendation. They said there may be a legitimate reason for referrals. For example, some payday loan providers may only target specific geographical locations, and if such a provider receives an application from a consumer in another location, they may wish to refer that consumer. The 10th recommendation is that providers should only be permitted to charge a default fee that represents their actual costs arising from a consumer default, up to a maximum of $10 per week, and that the existing limitation of the amount recoverable in the event of default be maintained, which you'll remember is twice the borrowed amount. The government accepted that the amount recoverable should be maintained, but rejected the recommendation relating to the default fee, stating that evidence from the payday loan industry suggested that $10 per week default fee was not enough to cover the costs of managing a defaulting borrower.
That concludes the 10 recommendations made relating to payday loans. I will now turn to the recommendations made in connection with consumer leases. There are 8 recommendations. So firstly, recommendation 11 is to introduce a cap on the total amount of payments to be made under a consumer lease of household goods. The cap should be a multiple of the base price of the goods, determined by adding 4% of the base price for each whole month of the lease term to the amount of the base price. The government accepted this recommendation. This would mean that a 2-year lease for a TV valued at $500 would be limited to total payments of $980. This recommendation has a particular impact when you think back to our case study client, Christina. This would mean that the payments she would have been required to make for her TV and computer would have been much less. The 12th recommendation is that the base price for new goods should be the recommended retail price, or the price agreed in store, where this price is below the recommended retail price. It was also recommended that further work should be done to define the base price for second-hand goods. The government accepted this recommendation for new goods, and it also proposed a base price for second-hand goods. This is excellent news for consumers, as it will prevent them from having to pay base prices which are above what the good would ordinarily be retailed for. 13th recommendation is that the cost of add-on features and services, aside from delivery, should be included in the cap. The government accepted this recommendation and provided that certain goods may be excluded from the cap where they have significant installation costs. The 14th recommendation is that the cap on consumer leases should apply to all household goods, including electronic goods. It was also recommended that further investigation should be taken into whether the cap should apply to motor vehicles. The government accepted this recommendation and stated that it will apply the cap on the cost of all consumer leases. The 15th recommendation is that consumer lease agreement repayments should be capped at 10% of the consumer's net income. The government accepted this recommendation in full. It was noted that responsible lending obligations appeared to be insufficient alone to prevent the observed harm, and that a more restricted or a more strict affordability test was warranted. This would be a very beneficial change for consumers and will help to prevent the cycle of borrowing. The 16th recommendation is that the Department of Human Services should consider making the caps in recommendations 11 through to 15 mandatory as soon as possible for lessors to utilise or seek to use the CentrePay system. The government supported this recommendation in principle, but stated that any response will have to account for the outcome of litigation between the Aboriginal Community Benefit Fund and the Chief Executive Centrelink. This litigation related to funeral insurance deductions through CentrePay. This change would be incredibly helpful in stopping the exploitation of CentrePay that we outlined previously. You will remember we have already alluded to the practice of consumer lease providers frequently and repeatedly exploiting CentrePay, a bill payment service for people receiving Centrelink payments. Many consumer lease providers take their fees automatically out of people's Centrelink payments before it even reaches their bank accounts. This means that people are left with less money to meet their essential living expenses, with the repayment of consumer leases effectively taking priority. The 17th recommendation is that the maximum amount that a lessor is able to charge on the termination of a consumer lease should be imposed by way of a formula or principle that provide an appropriate or reasonable estimate of the lessor's losses from the early repayment. The government accepted this recommendation and stated that it would undertake further consultation to finalise the formula or principles. We strongly support this recommendation, that charges be based on appropriate and reasonable estimates of lessors' losses. The final recommendation, specifically for consumer leases, was that there should be a prohibition on unsolicited selling for consumer leases of household goods. The government will place a ban on door-to-door selling on consumer leases, but not unsolicited selling as a whole, as it is difficult to distinguish between unsolicited selling and marketing.
Thanks, Roberta. So I'll now go through the combined recommendations for payday loans and consumer leases. So recommendation 19 was that the obligation that payday loan providers obtain and consider 90 days of bank statements before providing a payday loan be maintained, and that an equivalent requirement be introduced that lessors must also collect 90 days of bank statements. Additionally, it was recommended that a prohibition on using information obtained from bank statements for purposes other than compliance with responsible lending obligations be introduced. The government accepted this recommendation in full. It's noted that there's evidence that lessors are not making sufficient inquiries when providing a lease and may be in a position to make a more accurate assessment of consumers' circumstances if they collected at least 90 days of bank statements in addition to their responsible lending obligations. Recommendation 20 was that payday loan providers and lessors must document in writing their assessment that a proposed contract or lease is suitable, and this recommendation was accepted. The 21st recommendation was the introduction of a requirement for lessors under consumer leases of household goods to provide consumers with a warning statement, including informing consumers of the availability of alternatives to those leases. And this recommendation was accepted in full by the government. The 22nd recommendation was that payday loan providers and lessors should be required to disclose the costs of their product as an annual percentage rate, and that lessors of a consumer lease of household goods should be required to disclose the base price of the goods being leased and the difference between the base price and the total payments under the lease. The recommendation was partially accepted, with the government accepting that the difference between the base price and the total cost of a consumer lease should be disclosed, but not the annual percentage rate for consumer leases or payday loans. The penultimate recommendation was to extend the application of the existing civil penalty regime in Part 6 of the National Credit Code to consumer leases and to payday loans, and in relation to contraventions of specific obligations by payday loan providers and lessors, provide for the automatic loss of the right to their charges under the contract. And this recommendation was accepted in full. The final recommendation was that the National Consumer Credit Protection Act should be amended to regulate indefinite term leases to address avoidance of licensees of the restrictions on the maximum amount that can be charged under a lease or a payday loan, or any of the conduct obligations that only apply to consumer lease of household goods or payday loan. The government accepted this recommendation in full.
CCLS WA had the privilege of providing a submission in response to the Department of Treasury's final report of the review. We provided a response to the 24 recommendations that were made. The response we provided was based on our experience and the stories of our clients who faced issues with payday loans and consumer leases. Our response to the recommendations included the CCLS WA is currently assisting a number of clients who are in severe financial hardship due to debt spirals directly resulting from predatory lending. It also included the insight that for many of our clients we have advised no sensible assessment of their financial situation could result in the loan or lease being considered suitable. These were clients whose situations represented a clear trigger of the existing rebuttable presumptions of unsuitability. For example, we assisted a client to establish breaches of responsible lending in connection with her home loan, and despite being in obvious hardship in connection with her unsuitable home loan, she was able to obtain several concurrent payday loans. The need for these payday loans fueled by her inability to meet her living expenses while servicing her unsuitable home loan. No sensible assessment could have determined that the payday loans were given that were given that post-dated and helped to service an unsuitable home loan. CCLSWA argued breaches of responsible lending on behalf of our client, and we were able to secure her client a refund of all interest, fees and charges paid in connection with her home loan and the payday loans of over $90,000. After offsetting her personal debts with her home loan provider, she will receive nearly $50,000 cash in hand. I will now hand you back to Gemma, who will take you through the push for change.
Thanks, Roberta. So, as I said at the beginning, we had the idea of running this webinar last year. We thought by now that the recommendations would have been implemented and we would be here speaking to you about the new law. That hasn't happened yet. Back in March 2017, a number of consumer groups, including Choice, Consumer Action Law Centre, Financial Counselling Australia and Financial Rights Legal Centre, gathered in Canberra to lobby for urgent legislative changes. You can see more about the National Day of Action in the link to the 7 News report that Roberta referred you to in her slides earlier. Now, while the National Day of Action was a great starting point that garnered national attention, little legislative action has taken place. The government accepted the recommendations in November 2016, and in October 2017, Michael McCormack, the then Minister for Small Business, issued the National Consumer Credit Protection Amendment, open bracket, Small Amount Credit Contract Consumer Lease Reforms, close bracket, Bill 2017, as an exposure draft for comment. This was followed up in the same month by a statement from the Minister that the government will introduce legislation this year to implement the SAC and consumer lease reforms. 4 months followed, with no clear timeline for legislative implementation, highlighting the need to once again ramp up lobbying efforts. On the 14th of February 2018, Tim Hammond MP, Shadow Minister for Consumer Affairs, introduced the Labour Party's own legislative bill, replicating word for word the government's draft. It's now May, so 18 months from the government's response to the recommendations, and the time for action has come. CCLSWA is working with other community legal centres and financial counselling services to urge parliamentarians to pass the draft bill. So those of you who registered for the webinar and are watching it live have been provided with the pack of slides that's been put together by our colleagues at the Consumer Action Law Centre. I want to thank Denise Boyd for providing these invaluable slides to us, which gel so nicely with our presentation. Can I please stress to you, though, that these slides are for your use and purposes only and not to be distributed beyond your colleagues. I won't show you the slides here, as I'd like to make this webinar publicly available, but what I will do is just summarise some of the slides, and then we'll move on to the final quiz and answer your questions. So the slides are a great advocacy guide for us to use to lobby for change. They set out what works, such as how to tell your clients stories, how to arrange a meeting, and what evidence to bring to the meeting. They also contain contact details for Jonathan at Consumer Action Law Centre, who's happy to assist you with any questions. I worked with Jonathan on CCLSWA's involvement on the National Day of Action. Recently, Roberta and I have met with a couple of politicians in WA, and we've found the meetings to be very productive. So it's really important that we keep going and pushing with this until the legislation is passed. Okay, so that's the end of our formal part of our presentation, and we now have a short Kahoot quiz that will hopefully drive some of these points home. So what I want you to do is get out your smart devices and go to kahoot.it. And I'm just going to change the screen, so let's go onto the internet. Okay. So what we'll do is load up the quiz, and it will come up with a pin. So if you're all on kahoot.it, it will come up with the pin in a sec. All right. Okay, so if you can enter that pin into kahoot.it on your phones or tablets, the pin is 2028430. It'll ask you for your name or a nickname, so don't put anything inappropriate because it will come up on the screen. So we'll just give you guys a couple of minutes to log in. This is awesome. All right, hopefully you can see your names there on the screen. All right. Okay, well look, we've got 30 of you, 31 now registered, so Catwoman, fantastic. We'll start now. Some great names there. All right. So basically, we're going to ask you 9 questions. It's really straightforward. It's multiple choice. So you get 4 possible responses in each one, and you get 30 seconds with each question to make your decision. All right. We'll just wait for the first question to load. So what is a payday loan? Loans of any amount given on payday, loans given in the amount of your weekly pay, loans of up to $2,000 for periods between 16 days and 12 months, loans with high interest rates given by banks. So just select the number, the color and symbol for the answer that you think is the correct answer. 3 seconds to go. Okay, so 28 of you got it right. It's loans of up to $2,000 for periods of between 16 days and 12 months. And you actually get points for each correct answer, and the faster you answer, the higher points you get. So let's see who's leading. Shaq, well done. Okay. So what are some alternatives to payday loans? Negotiating with your utility provider, Centrelink advance payments, no interest loans, or all of the above. Okay, 10 seconds to go. Awesome. Okay, so it's all of the above. So even though, some of you might have answered red, blue, or yellow, you are technically correct, but the correct answer for the quiz is all of them. And now Kim's in the lead. Okay, so which of the following does not apply to consumer leases? There's no cap on fees. People may pay up to 3 times the RRP for goods. The person owns the good outright at the end of the lease. There is poor disclosure of cost. So what doesn't apply to consumer leases? So you can discount anything that does apply. So it is a bit of a tricky one because it's got the double negative. Okay, so the correct answer, which 23 of you got right, was that the person owns the good outright at the end of the lease. That doesn't apply to a consumer lease. You've got no right to own the good at the end of it. And Kim, going good guns. Okay, so what was the finding in the cash converters case? A breach of responsible lending laws for 118,000 loans, repay $10.8 million in fees, fined $1.35 million penalty, or all of the above? What was the finding in the cash converters case? Okay, all of the above, 32 of you got it right. But again, anyone who selected any of the others, technically you were correct, but for the purpose of the quiz, all of the answers were correct. Kim's still in the lead. So what was the SAC and consumer lease review? A review of the laws regulating SACs undertaken by CCLSWA, an independent review of SACs undertaken in 2015 and 2016, the government's response to complaints surrounding SACs, a review of financial counselling services in WA. 10 seconds to go. Okay. Yep, so this was an independent review of SACs undertaken in 2015 and 2016. P 2018 is in the lead now. Okay, question 6. What was the outcome of the SAC and Consumer Lease Review? The government accepted and implemented all recommendations. The government accepted and implemented some recommendations. The government is yet to implement the recommendations. The government is yet to comment on the recommendations. So make sure you read those responses carefully. What was the outcome of the SAC and Consumer Lease Review? 5 seconds to go. That's right. The government is yet to implement the recommendations. So the yellow one, 22 of you got that right. Catwoman is in the lead. All right. Which of the following does not apply to payday loans? They have high establishment and monthly fees. There is no cap on default fees. People can only have one at a time. They may lead to a debt spiral. So again, this is one of those tricky double negatives. So discount any that do apply to payday loans and just pick the one that doesn't apply. 5 seconds to go. All right, people can only have one at a time. Yep, that doesn't apply to payday loans. All the other ones do apply. They have high fees, there's no cap on default fees, and they may lead to debt spirals. Siobhan now has taken the lead. Okay, bonus question. What areas does CCLSWA specialize in? Financial counseling services, pro bono legal representation, banking, finance and consumer-related disputes, or bankruptcy? So what do we specialize in? Okay, a couple of seconds to go. Yep, banking, finance and consumer-related disputes, 27 of you got it right. Siobhan's still in the lead. Final question. Which of the following is a recommendation that should be enacted? A cap on total repayments of consumer leases, 10% protected earnings cap on monthly repayments, more funding for financial counseling and consumer advocacy, or 1 and 2 only? And when I say 1 and 2, I mean the red and the blue ones only. So is it red, blue, yellow, or green? What's a recommendation that should be enacted? Okay, yep, 1 and 2 only. I see one of you has picked the yellow one, more funding for financial counseling and consumer advocacy. That wasn't a recommendation, but yeah, we agree with whoever selected that because we do think there should be more funding. So final winner was Siobhan. Next was LB, and then Ames. Well done, guys. Thanks so much for paying attention to our webinar. That's pretty much 11 o'clock on the dot now. If we have any questions, if we have time, we're happy to answer any, but we've got a slide here which has got all our resources on it and contact details.
Okay, that was fantastic. Thank you. I hope everyone, or most people, got into that quiz at the end. That's a really great way to actually assess that everyone was paying attention. So well done, and thanks for participating. So we do have some questions that have come through, guys, so I'll get straight into them if that's okay. So firstly, this one from Gail. Where does Afterpay sit within the current system, and will the new laws affect them? So that's a very common way to pay for goods and services now as well.
Yeah, absolutely. I don't think you can go past a store in the high street without seeing Afterpay. Look, Afterpay doesn't come under the National Consumer Credit Act or credit code. It isn't credit, which is a big, it's unregulated at the moment. So no, these new laws won't affect Afterpay. The current laws don't affect Afterpay. It is something I think the regulators are looking into, as in ASIC, because they're really unsure on where this sort of product should actually fall. But yeah, it isn't credit at the moment.
Okay. So this one from Murray, bit of a comment perhaps. TV advertising are not taken into account when looking at the ban for unsolicited marketing. Do you have anything to say there?
No, I think the ban is on direct marketing in terms of, contacting clients that have previously had payday loans. But yeah, as far as I know, I don't think there's anything about bans on TV advertising yet.
Okay, great. This one is actually a really good one, and I have seen a little bit of this around as well myself. So this one's from Chris. I read that New South Wales has ATMs that offer instant cash loans. They are placed near smoke shops. All the person needs to do is provide their license and bank details to apply. Does WA have those yet? Will they also come under the new laws?
Yeah, I've heard about these. I'm not aware of any appearing in WA at all, but I've definitely heard the same stories that they're in New South Wales. I believe Queensland may actually have them as well. And applying for a payday loan through one of these machines, so like Murray said, it's like an ATM machine that you just apply online through this machine, and then you get the cash instantly deposited, in your hand. So how on earth the actual lender could possibly comply with their responsible lending obligations by giving those loans out, I really don't know. But as far as I know, I've not heard about them being in WA, and I don't know whether there's any plans to introduce them in WA either.
Right. They do really seem quite troublesome, and there are a couple of other comments and questions that have come in relation to those cash loan machines. So this is just a comment here from Siobhan. I question how they are meeting responsible lending provisions, let alone the increased payday loan obligations. So far as I know, they aren't using the no interest charged loophole of Afterpay and others that are similar to that.
Mm-hmm. Yeah, we agree.
Yeah. This one here, so this is a bit of a technicality around the 10% proposed cap. Is that 10% of fortnightly income for Centrelink recipients, or 10% of annual income, or is it 10% of a 2-year income on a 2-year consumer lease? Thanks, Alan.
Well, what it applies to is actually the repayments. So the repayments can't be more than 10% of the consumer's net income. So if the repayments are going to be being made fortnightly, then it's going to be looking at the fortnightly income and expenses and what's left over.
Okay, fantastic. So just a reminder, for any last minute questions that you'd like to ask, you can type those into the question box on the GoToWebinar control panel. So I've just got another one here, another comment. Mary would like to see Centrelink provide their clients with a list of the benefits they can receive, such as discounts on car registration, etc. I think that's everything for today. We've got some positive feedback coming through as well, so I think everyone really enjoyed that and hopefully got a lot out of it. So on behalf of everyone wildly clapping and cheering at their screens, thank you very much, guys, for presenting today. For everyone else, I will be putting this recording up onto our website, and I'll send the link out to everyone who's registered so that you can have a watch of that one later, and the PowerPoints will also be placed up there. So thanks everyone for tuning in, and make sure you do provide feedback on today's webinar, which will also come out in the link that I send you this arvo. Cheers. Thanks everyone. Bye.
Thank you. Thanks everyone.